I'm trying to figure out whether I saw this coming, but I feel as though it's a 50-50. In case you haven't heard, Justin Baldoni's case has been dismissed. Not entirely, but pretty much 80% of it out. And while we're here, before we get into things, I also want to make two things clear. Firstly, I am just the messenger. I'm using my training and my skills as a lawyer to interpret the court's decision and explain it to you, hopefully in layman's terms. This was a 132-page document, by the way, so you're welcome. Secondly, the court, in this case in particular, Judge Lyman, I think is how you say his name. I've been saying Lehman for months now. Apparently it's Lyman, and he's the brother of a Hollywood director, I think. But I digress. I've read his judgment very carefully, and he is very by the book. This actually, to me, in my opinion, was a very well thought out and written judgment. Because unlike the judge in the Johnny Depp trial in the UK, this judgment was full of judicial reasoning. It was full of citations upon citations of relevant case law, which the judge is bound by, or at least guided by. So it's not like the judge came up with this decision on a whim or based on his instincts. What I think happened here is, on the one hand, the Wayfarer parties had a very strong narrative, a very strong story. They obviously also had some type of evidence that we have been privy to that lends towards their case. You can have an otherwise compelling case that will fail on a technicality. It reminds me of the Alec Baldwin Rust case, which also failed on a technicality. A woman died as a result of what has been alleged to be Alec Baldwin's negligence, in addition to the armorer and other people. But the case against Alec was dismissed, dropped, and because of double jeopardy, it can never be brought again. Why? Upon a technicality. To begin with, I do want to make clear that at this stage, at the stage that the order was made, the court is assuming, just prima facie on its face, that the Wayfarer party's allegations are true. So he's not sitting there going, I don't believe in your allegations. We're just going to assume they're true. However, do you have a case? Have you pleaded your case correctly? Starting off with the civil extortion claim. Now, Wayfarer brought this claim in relation to the whole, if you don't do this, then the gloves are off, and if you don't sign this return to productions document, then I'm not gonna perform my duties, and I'm not gonna show up, on set, etc., etc., etc. So they're claiming they're blackmailed, essentially. However, unfortunately, as Ryan Reynolds' lawyers very correctly stated in their motion to dismiss, civil extortion, as far as California is concerned, only takes place where a plaintiff gives a defendant money or property under threat and seeks to have it returned. So it's a very narrow set of circumstances. Mere blackmail, mere threats, without the deprivation of the plaintiff of such property or money, don't cut it. On top of that, the plaintiff must have acquiesced, so given in to the threats, and suffered damages as a direct result of doing so. So that's the general stance. But first, let's focus on the gloves are off comment. That famous threat that the Wayfarer parties allege they receive if they didn't make a public apology or release a public statement, basically taking the blame, being the fall guy for all the backlash against Blake at the time. Based on what I had just said, which is mere threats are not enough and the plaintiff must have acquiesced, the judge points out that the Wayfarer parties didn't cave in. They actually didn't acquiesce. They didn't issue that public statement. And so there is no cause of action. It ends there. As for the return to productions document, we know that the Wayfarer parties claim that they were forced to sign that just to make sure that Blake returned to her job, reported to duty, and fulfilled her quote-unquote obligations to promote the movie, etc., etc. She also had additional requests, if you remember, such as getting a PGA mark, being credited as a producer, and making her own cut of the movie. Here, the judge points out that Blake never threatened to do things. Rather, she threatened not to do things. Things which potentially would fall under breach of contract. And so they weren't deprived of a suitable alternative remedy, assuming she was bound by the contract because there was all this talk that she never really signed it, or it took her months and months and months to even send over a signed copy. Now, what the Wayfarer parties have argued is that her going to the New York Times and sharing her California complaint was basically Blake Lively following through with her threat. But the judge then says, yeah, okay, but that's actionable under defamation, not civil extortion, because it doesn't meet the elements, the very strict and narrow elements of that cause of action in California. There's also the issue of the Wayfarer parties not clearly pleading what Blake's contractual obligations were. And that's the thing about court pleadings. You really have to be precise and as brief as possible. That's how we're trained. It was all about brevity, 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 and clarity. There was a lot of vagueness and ambiguity in the sense of they used a lot of assumptions and reliance on the term on information and belief, that came up so many times, so much so that the judge pointed it out in his judgment as problematic, because that just doesn't cut it in a court of law. Show me the evidence. When it comes to Blake's refusal to act, now obviously, you don't have to, I suppose, see a contract to assume that an actress has a contractual obligation to do her job. The judge says that the Wayfarer parties failed to allege or claim that Blake had an obligation to show up and act and do her job under any circumstance, no matter what happens. They didn't show that to be true. To illustrate his points, he used an example of just a regular employee who may also stipulate legally that they are not going to show up at a workplace unless their insistence on more workplace protections are adhered to. That in and of itself does not amount to
extortion.
That's someone trying to bargain so that their workplace is a safe environment for them to be in. What's more is that if the employer gives in to these demands, that employer cannot then at a later date say that they were forced to agree. They, of their own accord, decided to go ahead. I really cannot stress enough how what we see as duress, what we see as threats and blackmail in the real world outside of a courtroom is very different to what the law recognizes. In terms of the whole taking over the production allegation, namely threatening that she won't promote the movie if she doesn't get to make her own cut, the court found that these demands did not involve a disproportionate exchange of value. She wanted to take on these additional jobs, which Justin Baldoni and Wayfarer saw as a hostile takeover, for free. And with regards to the cut in particular, the judge noted that it was unclear in the pleadings, in the Wayfarer party's pleadings, who had the ultimate right to choose the cut of the film. Was it Sony or was it Wayfarer? According to how the complaint read, it was Sony. And if so, then that's all the more reason to deny the Wayfarer civil extortion claim, because Blake wouldn't have been withholding from Wayfarer anything that they had a right to. It was Sony's right, and they were the ultimate decision maker. And mind you, we then go back to the whole contract thing. Even if they had the right, they had an alternative remedy to sue for breach of contract. I've always maintained that defamation is an incredibly difficult cause of action to make it all the way to trial. It rarely does. And once again, the fatalities here lie in a few defenses, to be fair, which we'll get to, but also in pleadings that were deemed to be too vague, too ambiguous. You're not telling me exactly what statements you're relying on. So, as it relates to Blake and the New York Times, the judge found that a fundamental obstacle to the defamation claim is the Wayfarer party's failure to plead exactly what, if anything, the Lively parties and the New York Times communicated to each other. So their pleadings contained a lot of that line, that phrase, on information and belief. And in a court of law, when it comes to proving defamation, that's not going to cut it. Then there's the issue of defenses. Now, I've mentioned time and time again that Blake's complaint is protected under the doctrine of absolute privilege. Now, the issue here lies within the fact that basically all of Blake's allegations emanate from the California civil complaint. They're all housed in there, and so they're untouchable. And because this privilege is absolute, it's not qualified, any allegations of evidence being doctored don't defeat the privilege. You can go to court and even write in a statement that so-and-so is a sexual predator, and they can't sue you because you've said it during or in connection to judicial proceedings. I think we covered fair report privilege when I talked about how the New York Times wants out. I also personally went through their article and pointed out statements that I don't believe were at all housed within the complaint and therefore are beyond the remit of its protection, which I actually wasn't too far off on, by the way, because the judge also pointed out, I think the same statements, maybe not all of them, but at least a couple, that he did find to be beyond the protection, beyond the remit of fair report, because they weren't housed in the California complaint. But they failed anyway, and we'll get to why. I just don't want to get ahead of myself. The court found that all the claims in the article that relate to Blake's allegations of sexual harassment actually do emanate from, so they're sourced from, the California complaint and are therefore protected by the fair report privilege, which stipulates that parties cannot be held liable for giving a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding, and a report is fair and true if it is substantially accurate. Now, in this instance, the source, which is the complaint, may not be fair and true, and so it's not fairness as we know it. It's just, does it accurately summarize the complaint? If yes, the privilege applies. I have pointed out before, I think in Ryan Reynolds' motion to dismiss and the New York Times motion to dismiss, that actual malice is going to present a problem for the Wayfarer parties because it's a subjective test. You're going to have to get in the mind of Ryan Reynolds and the New York Times reporters and prove that they knew that the statements, the allegations were false or had a reckless disregard for its veracity. They didn't care. And usually in the law, we look at the reasonable person. Any reasonable person in Ryan Reynolds' position as a husband wouldn't necessarily have a reason to doubt the veracity of his wife's allegations. And as far as he was concerned, what she was saying was true. The New York Times, she provided them with the complaint itself. It's a legal document, it's official. They had no reason to doubt its authenticity and veracity. In addition to a report made by some online analyst about the smear campaign. And then there were the text messages. And so what the judge is saying is basically they were presented with a lot of verified, authentic documents as far as they were concerned. And so they had no reason to doubt the documents before them. So the judge goes through examples of the texts between Melissa Nathan and Jessica Abel. Yes, they may have been doctored, but as far as the New York Times were concerned, they had enough material to believe that narrative to fall short of the incredibly strict and high threshold of actual malice. Now, the judge does point out that the Wayfarer parties say, no, but there were other text messages that the New York Times had access to, and they presented a different story. However, the judge says, yes, okay, but that would at most mean that the Times had a number of possibilities to believe, to pick from, I suppose, and that is not enough to create a jury issue of malice. So basically, choosing one person's version over the other does not equate to actual malice. Very quickly, with the rest of the causes of action that failed, false light, invasion of privacy is basically defamation light. That's how I've described it multiple times. And so, once again, Ryan Reynolds and I think even Blake's lawyers were correct in that, look, their defamation case is hopeless. Their false light invasion claim is identical to the defamation claim. It's based on the exact same statements. And so if the defamation claim fails, then the false light invasion of privacy claim has no way of surviving, and they were found to be correct. The judge agreed with them. We also covered the promissory fraud and breach of implied contract with the New York Times when I covered their motion to dismiss, and they were correct too. Basically, they said, look, we gave them a chance to provide us with a statement. We gave them a window, a time frame, and a deadline. And so since the Wayfarer parties responded before that deadline, we didn't wait to publish the document. That deadline was a deadline for their response, not a deadline for the publication time. And they did in fact put in their response exactly as it was. It wasn't paraphrased, it wasn't summarized, it was a copy-paste job. Now, where the Wayfarer parties do have a hope of at least refiling are these two causes of action: the breach of implied covenant of good faith against Blake Lively and the tortious interference with the contract allegation, the one in relation to the contract between Justin Baldoni and WME. Now, the reason these two claims failed are reasons that we have discussed before. Namely, the pleadings were not clear. The Wayfarer parties didn't specifically plead the relevant terms of the contract. All their amended complaint contained were, as the court points out, vague references to contract negotiations or entitlements. But then it also goes on to say several times that Blake never signed her employment contract. And so you have this double issue of, did she even sign the thing in the first place? And then, which specific provisions of the contract are you alleging she breached? We don't know. You never told us. Same goes for the WME contract. But as I mentioned, that's not a permanent fatality. Does that even make sense? Like, fatality always implies permanence. My point being, you understand what I'm trying to say, I'm sure. They can refile on those 2 points. So what have we learned here? Firstly, the importance of clarity in your pleadings. Pleading particulars. You have to be clear in what it is you are alleging. If you are not, even if you have a strong case, it can still get tossed out on a technicality. I think for young lawyers such as myself out there, this is a learning lesson for sure. We can also learn how the strength of a narrative can be so compelling in the court of public opinion, but that within the confines of the legal framework, you can have an entirely different story. But that's about it. Blake and the other parties have filed motions for fees and damages, but that has been dismissed without prejudice, so they can refile at a future date. And Justin and the other Wayfarer parties have until June 23rd to file the amended complaint for the 2 breaches of contract and tortious interference with contract claims. It remains to be seen if there will be an appeal. But with that, this video is getting long enough as it is. I'm going to end it here. I suppose let me know what you think, even though what we think really doesn't matter when it comes to this. All right, it's time for some lunch. So take care and don't get too mad in the comment section. It's not good for your health.